reached you that
it has
prepared to sit tomorrow afternoon if need be, so you each have an additional hour if you require it.
No, so that's extremely kind of your lordship and your ladyship, and there you could see that we're obviously having difficulty trying to cover a complicated matter at the time available. Just to say, we may not take the whole of our extra hour this afternoon. We may leave some additional time because we were planning to have just half an hour for reply. So our aim at the moment is to try to put the revenue into bat by 3:15.
Yes.
That's right there. I'm afraid I dealt with the first two substantive arguments at a rate of knots, and I didn't give your lordships and your ladyship any real opportunity to ask any questions. I hope I've elaborated on the points that we had in our written case. If you have any questions on those first two submissions, I'm not proposing to go over them again, but what I may do is, in the third and fourth submissions, perhaps pick up some of the factual matters that I didn't give you references to when I dealt with particularly the second submission on tax mitigation. So I'll turn then to the third of our submissions, which is concerned with the purpose of avoiding liability to taxation. And that relates to the element of the motive defence in the second limb, which says that the transfer must have been not designed for the purpose of liability to taxation. I'm going to focus here on the purpose of avoiding liability to taxation. Our fourth submission looks at the element of design, and also under the fourth submission I will deal specifically with how the Court of Appeal dealt with the upper tribunal on the issue of the motive defence.
I should have mentioned, just before you embark on this, just to mention we have now received the two Vesti judgments, the first instance of Mr. Justice Walton. I hope the respondents have those as well.
That's excellent. We were looking for them. I don't know who sent them to you. That's excellent. Marvellous. Now, just to note that these submissions are, of course, made on the assumption that I have not persuaded you that the avoidance of taxation doesn't include betting duty, nor have I persuaded you that the transfer in February 2000 involved tax mitigation. If I persuaded you on those 2 points, then, of course, you don't need to consider this issue. There will obviously be an element of overlap with our submissions, particularly on tax mitigation, but they were taken very, very fast. Our submissions here are that the first-tier tribunal made errors of law in connection with identifying the purpose of avoiding liability to taxation, which, in the context of the second limb, means the main purpose of avoiding liability to taxation. For the moment, I'll ask you just to take that from me, but I will take you to the authority, and it's a point that's been accepted throughout the hearing. The Court of Appeal regrettably continued the errors of the FTT when it reversed the upper tribunal on this motive defence. Now, our submissions here fall into two groups. First, and this is similar to the submission made with regard to tax mitigation, but it focuses somewhat differently, and that is that the FTT failed to focus on the transfer which is said to give rise to the liability, that is the transfer from SJA to SJG, which took effect from the 29th of February 2000. Second group of submissions are that the FTT confused the purpose of the transfer of assets as a means of saving the business. They confused that with offering duty-free betting to respond to the unfair competition that that the fishers were facing from competitors. And in that context, they the FTT wrongly disregarded the Section 9 concerns of the Fishers. So you'll see that there's a certain amount of overlap with the tax mitigation. If I take the first of these issues, I ran through the facts at a pace of knots before lunch, so let me take it a bit more slowly. By the time of the transfer of assets at the end of February 2000, SGA was already operating through a branch in Gibraltar. The business to that extent had already been saved from total destruction by the unfair competition, and they were already able to offer duty-free betting from the branch. But as I explained earlier, they had been in discussions, Peter and Stephen Fisher, with Customs and Excise, and details of the correspondence, I didn't give you a reference to that, but the correspondence is set out at paragraphs 358 to 366 of the FTT's decision. And that culminated in September 1988 in Customs and Excise informing SJA that betting operations had to be set up as a separate legal entity. And that's FTT paragraph 363. The Fishers also took advice from leading counsel David Oliver QC, who also advised that it was necessary to establish a separate company to reduce any risk of an offence under Section 9 BGDA, and that's FTT paragraph 346. There are then several findings of fact by the FTT that both Stephen and Peter understood that a separate entity was necessary if they were to accept bets from UK punters and not contravene Section 9. The findings in respect of Peter are at FTT paragraphs 440 and 441, and those in respect of Stephen are at paragraph 384. And there the FTT said, we find Stephen Fisher did genuinely believe that UK source bets would need to be taken by a separate legal entity. It's consistent with his concerns about Section 9 conducting in Great Britain any business or agency for the negotiation, receipt or transmission of bets. The Fisher's submissions are that when one focuses on the transfer to which Section 739 might apply, that is the transfer of the telebetting business, the main purpose of that transfer was to ensure that the telebetting business continued to operate in a way that did not infringe the restrictions in Section 9 by operating through a separate legal entity. Now, the error of law of the FTT was in not identifying the correct transfer to apply Section 739 and confusing the transfer of the business to Gibraltar, which had taken place before July 1999, with the transfer to SJG in February 2000. Now, in their written case at paragraph 71, that's electronic page 86, HMRC characterized these submissions as a straightforward attack on the findings of the FTT, which specifically rejected the factual assertion that the purpose was to avoid the risk of prosecution under Section 9. But with respect, these are not challenges to the factual findings, but to the FTT's failure to identify the correct transfer to which 739 might have applied, and that was the transfer from SJA to SJG. They confused that with the transfer of business to Gibraltar, which had already taken place. And if you identify the transfer...
What was it that was transferred from SJA to SJG?
I'm sorry?
What was it that was transferred?
It was the business of the partnership sorry, not the partnership, it was the business of the branch that was already operating in Gibraltar, and what remained of the business of SJA in the UK. Specifically, it was a list of customers together with free phone telephone numbers and a teletext account. And the details of that are in the agreed statement of facts and issues.
Well, the details are also set out very clearly by the FTT, aren't they?
Yes.
And you say they focused on the wrong transfer, but under the heading transfer, above paragraph 76, page 263 in the key bundle, they go through very specifically focusing on the transfer of the business.
But the transfer of the
Paragraph
business...
81, it talks about the business sold.
Yes. But when they talk about the transfer of the business elsewhere, they talk about the transfer of the business being the transfer necessary to ensure that they were able to offer duty-free betting. For example, paragraphs 456 and 457, in connection with the transfer...
What page is that of the core bundle? Not to worry, it's okay.
I've only got the paragraph numbers.
Not to worry.
It's page
323.
I think it's 323. They talk there about going to a jurisdiction where duty was less, and there is no point in going to Gibraltar unless the duty rate was lower. That's focusing on being able to offer duty-free betting, because that's when they were going to the jurisdiction by setting up the branch and then operating from there. The revenue at footnote 14 seek to respond to our submissions that the FTT was focused on the earlier decision by referring to passages identified at footnote 14. I think one of the passages is one of those that Lord Sale, you were referring to. But neither of those passages make it clear that the transfer they were considering was the transfer from SJA to SJG.
Well, that is what I was putting to. Don't paragraph 76 to 94 make it clear that they are focusing on the transfer of the business? Because at paragraph 81, they say what the business sold was, and that they go on then to analyse the position of SJG afterwards and SJA afterwards. And that's all under the heading transfer before they then turn to the law.
But that's in the context where they have been discussing the move to Gibraltar in the context of taking bets from UK residents. And that's where paragraphs 57 onwards, they're talking about the branch taking bets from UK residents. And that was the point in time at which the duty-free betting was initiated. And so when they talk about the purpose being the avoidance of betting duty, from that time onwards, there was no betting duty exigible on the bets. The branch was already offering duty-free betting from that time onwards.
Right, but forgive me for interrupting. I thought the point you were making was that the FTT focused on the wrong transfer, and that they focused on the transfer of business to Gibraltar rather than the transfer of the business between SJA and SJG.
When they came to apply the motive defence, they considered that the main purpose, or one of the main purposes, was the avoidance of betting duty.
Right.
Any betting duty was not payable from July 1999 onwards because the branch was operating, and so they were focusing at that time on the wrong transfer. It's quite correct in terms of the findings.
But, well, so you are saying they're focusing on the wrong transfer, but the point I wanted to ask for your observations on, in paragraph 57,
yes,
they don't even describe it as a transfer. So in their recital of the facts, what is described as the transfer is the transfer of the business between SJA and SJG, not what you've been describing as the transfer of the business to Gibraltar.
When it's in the findings of fact, you're absolutely right, my lord, they identify what assets were transferred, and they identify at that point that the transfer was the one that took place at the end of February 2000. But when they come to look at the purpose in the context of the motive defence, there they say that the purpose was saving the business, ensuring the business was not completely lost. That could be achieved by offering duty-free betting, and that was the avoidance of betting duty. And so when they're applying the motive defence, and this is much later in their judgment, it's in the discussions of the motives of Peter and Stephen, particularly.
What one sees is the point you're making emerges, for example, in paragraph 455 on page 323. Not 323.
Yes, yes. Well, I've mentioned 456 and 457.
Well, you say that because Section 9 concerns the consequence of an underlying objective of effectively avoiding betting duty, therefore the ultimate purpose was the avoidance of betting duty.
Yes. But they were already operating without having to charge betting duty before that transfer, which
that's correct. But the process of incorporation of SJG, as I understand the findings of fact, predated the obtaining of the advice about Section 9. If you look at paragraph 62, you know that on the 7th of July, paragraph 57, that Stephen wrote to HMCE to tell them of their intention to begin taking bets in Gibraltar through the branch. And we note that before 22nd July, that Peter Fisher had given instructions for the incorporation of SJG.
Yes.
And the David Oliver advice came thereafter.
Yes. But prior to that time, they had been advised by Customs and Excise
Oh, indeed.
they needed to have a separate company. They formed the company, but nothing was transferred to that company until February of 2000.
Yes, all I'm saying is that you are criticising the FTT for saying that it needs to be looked in a composite way, the transaction, and it does seem that the decision to take bets from the UK from the branch was something being considered at the same time as the incorporation of a separate Gibraltarian company.
That is factually correct, and that would reflect the fact that they'd been advised by Customs and Excise previously. Nevertheless, the actual transfer to which Section 739 is said to apply is the transfer by which income arises to a non-resident person. No income arose to SJG from its incorporation. Income only arose after assets were transferred to it. The business was transferred to it in February 2000.
Yes, but indeed, you're focusing on the date of the transfer and the passage of time between the opening of betting in the branch. But it seems that the factual narrative, which we see on 262 and 263 from paragraph 57 onwards, seems to suggest that there was a continuum of planning throughout that period towards setting up a Gibraltarian company.
I can't disagree with your lordship. The company was set up, but nothing was transferred to it at that time. And as you said earlier, subsequent advice from David Oliver that they needed to operate through a separate company came subsequent to the incorporation. It should be mentioned that Victor Chandler, the competitor who'd gone abroad, had formed a separate company from the outset. And so looking at what their competitors were doing, as a separate company had been used there. But the point that I'm making is when you come to look at the transfer to which Section 739 is concerned, they were already operating and had been for 8 months without betting duty.
But that wasn't really much of a business if they couldn't advertise for people in the UK to place their bets in Gibraltar.
Well, they could after the decision of Mr. Justice Lightman in the Victor Chandler case, because they could use teletext.
Yes, but then they couldn't when that was overturned.
That was overturned
Yeah.
on
So
exactly
then
the
it
same
becomes-
day
yeah.
as the transfer took place to the separate company. But by that stage, there was no longer any telebetting in the UK. All the business had moved abroad, and the punters had already established that they could bet duty-free in Gibraltar. So there was no longer any need, in effect, to advertise. The punters already knew about this.
I was a little uncertain about whether there was telebetting business was continuing, because at paragraph 320, page 303 of the core bundle, the FTT find on the evidence that although it was dwindling, it still continued.
But it was dwindling, and there was, when the transfer took place, there was a residual business from the UK. It wasn't only the business in the branch, but there was a dwindling business that was that continued in the UK.
So the transfer did in fact transfer an existing business from the United Kingdom to Gibraltar.
Yes, it transferred, as it in reply to Lady Rose, it transferred the business of the branch in Gibraltar and the diminishing business from the UK. Yes, but by that stage, as I say, they were already able to operate duty-free through the branch in Gibraltar. If I may move on, the second of our submissions is that the FTT confused the purpose of the transfer with the means of saving the business, which was to offer duty-free betting to respond to the unfair competition that they faced from their competitors. On that point, we make the point at paragraph 98 in our written case that the burden of betting duty was always borne in the case of UK punters under the old regime, by the punters. The whole issue of duty-free telebetting arose because punters could bet with the competitors duty-free. It would have been ruinous for SJA to seek to absorb the cost of the duty. The duty exceeded their profit margin. And that reinforces the point, because the incidence of the betting duty and the saving of tax was by the punters, that avoiding betting duty was not the purpose of the fixtures.
But there wasn't anything illegal about you absorbing the betting duty if you chose to do that, or part of
nothing
the betting.
illegal, but economically ruinous.
Yes, but it's not the case that it was required that the punters pay this in order to make it more expensive and therefore perhaps dissuade them from. That's not how the legislation worked.
No, the legislation worked, but a UK company, UK bookmaker, had to charge. And the practice in the industry was to charge a 9% surcharge on the bet. An overseas bookmaker did not need to charge anything at all. The question may be asked, could SJA not have responded to the competitors by absorbing the 9% themselves? The answer is that would have been ruinous. Their margins were 6%. The charge was 9%, that would have, absorbing that would have wiped out their margins. Their only response to the competitors was to be able to offer duty-free betting. As it happens, and this gets back to Lord Stephen's question, they did actually have to bear from Gibraltar the cost of the Gibraltar duty. There was a 1% duty in Gibraltar. In the case of the UK, they charged 9% when the duty was 6.7 or 7.75. That meant that they actually were left with a small surplus after they charged the 9%. In the case of Gibraltar, there was a 1% duty, but they had to absorb that themselves, so they actually did bear expense. I was reminded by the Fishers that they did actually bear expense from having to bear the Gibraltar duty. The reasoning of the tribunals below was essentially this. The Fishers had a purpose of saving their business. In order to achieve that end, it was necessary to avoid betting duty. Therefore, they had a purpose of avoiding betting duty. Now, aside from the fact that we say that focuses on the wrong part of the process, it focuses on the earlier decision to take bets from Gibraltar. It confuses the means of saving the business with the Fisher's purpose. Even assuming that saving the business was also relevant to the sale to SJG, offering duty-free betting was not a purpose in itself. It was simply a means to achieve the saving of the business. Punters would not bet with Stan James unless they could offer duty-free betting, as could their competitors. The Fishers did not set out with the purpose to avoid betting duty, but in respect of the transfer of February 2000, they set out to avoid offending Section 9 BGDA. Again, HMRC's written case at paragraph 72, electronic page 87, contends that this argument is contrary to the findings of the FTT, and it's not open to the Fishers to argue that the objectives of saving betting duty and saving the business were distinct. However, our submission is not seeking to argue that the objectives were distinct in the minds of the Fishers. Rather, our argument is that the tribunals below erred in considering that the avoidance of betting duty was a purpose when it was simply a means to save the business. HMRC's written case, paragraph 73, contends that the premise of the Fishers' argument is misconceived. Tax avoidance is never an end in itself, but is undertaken with the objective of reducing expenditure which can be used for another purpose. And therefore the interpretation advanced by the Fishers would mean that all transferors could benefit from the mode of defence. But the error in that submission explains exactly why our argument is correct. The transfer from SJA to SJG did not reduce expenditure, which could be used for other purpose. Rather, they had to undertake additional expenditure in establishing the company in Gibraltar and transferring the business there. They were no better off at all, save insofar as they managed to save their business. And that particularly arose from the fact that the incidence of the tax fell on the punters. It's possible that the particular circumstances of telebetting in 1999 are unique. It's not a usual situation where the threat to SJA's business came as a direct result of the UK betting regime. It's an unusual situation that the threat to a business arises directly from the operation of the tax system. As I said in opening, the betting duty had not kept up with technological developments. SJA faced unfair competition from other bookmakers who'd moved abroad, and Section 9 no longer provided protection. Stephen Fisher had for many months sought to persuade HM Customs to amend the legislation, but they'd not done so, and the only way to complete was to move offshore. Offering duty-free betting was a means to save the business, not the purpose of the transfer. And those are our submissions on the purpose of avoiding liability. Our final submissions are focused on the second limb and the requirement that to show that the transfer and any associated operations were not designed for the purpose of avoiding liability to taxation. And they focus on the inclusion of the word designed in that second limb. HMRC, in their written case at paragraphs 75 to 79, object to these submissions on the grounds that they were not made before the FTT. Now, it's correct that at the FTT, the focus was on tax avoidance purpose in general, and on the first limb of the defence. But the FTT does deal with the second limb at paragraphs 521 to 546. The Revenue have presented and referred to the transcripts of the hearing. And it's clear that the late Stephen Brandon, QC, who represented the Fisher at the hearing, did make reference to the requirement of design. That's electronic pages 1022, 1027, and 1028. I appeared for the Fishers before the upper tribunal, and I most certainly did make submissions in relation to the requirement of design, and that's recorded by the upper tribunal at paragraph 125, subparagraph 6, electronic page 191, and at paragraph 139, page 194. If HMRC were to object to these submissions, that was the time that they should have objected, and they did not do so. The issue of design, we say, does not raise any different issues from those heard before the FTT, nor will there be any difference in the evidence that was heard. The FTT heard the full evidence of the background, and it's hard to understand HMRC's comment in paragraph 77 that there would have been different considerations. There's very little authority on the meaning of the second limb of the 741 defence. One of the few discussions is the Special Commissioner's decision in Carville, which is electronic pages 121 to 1212 to 1240. And the discussion of the point is at electronic page 1235. I'm not going to ask you to turn to it because I will actually read the quotation, if I may. It's paragraph 89. The history of the legislation was referred to. Originally in 1936, there was a single let-out provision exempting the transfer of assets effected mainly for some purpose other than the purpose of avoiding liability to taxation. Section 28 of the Finance Act 1938 changes to the present wording of 741, which in paragraph A applies a more stringent test of one of the purposes of the transfer and associated operations not being tax avoidance, and in paragraph B merely refers to the transfer and associated operations not being designed for that purpose. Clearly, this cannot mean one of the purposes for which it was designed being tax avoidance, because otherwise paragraph B would add nothing to paragraph A. It is odd that Parliament did not lay down any level of purpose in paragraph B when it was replacing a test which depended mainly on tax avoidance, with a test in paragraph A depending on none of the purposes being tax avoidance. It was obviously clear that from paragraph A that a transfer could have more than one purpose, and therefore in paragraph B could be designed for more than one purpose. One must ask in paragraph B whether the transfer was designed for the purpose of avoiding tax or not. This seems to me to require that the main purpose was not tax avoidance, because if one has to categorize a transaction as being either designed for the purpose of tax avoidance or not, when it's clearly accepted that a transaction may be designed for more than one purpose, the only way to categorize the design into one purpose is to look at the main purpose of the design. We say that that explanation is a correct explanation of the legislation, and that in applying the second limb, it is necessary to look at the main purpose of the design. And I made that submission before the upper tribunal. And we take from this 2 points. First, to distinguish the second limb from the first limb, the transfer must be designed for the main purpose of avoiding liability to taxation. Second, it's not simply enough to look whether the main purpose was the avoidance of liability, but whether the transfer was designed for the main purpose. Design has more than one meaning. And we have contended that the third meaning in the Oxford English Dictionary, which is set out at paragraph 141 of our written case, that it means to fashion, sketch, draw, to conceive and make drawings and plans for a building, etc. That is, in the case of a bona fide transaction, there has to be some element of design of the transaction. And the main purpose of the design has to be the avoidance of tax. The set of facts that one is usually considering in the context of the second limb is one where a taxpayer is planning a commercial transaction but asks a tax advisor to add features or in some way design the transaction so the tax avoidance purpose is achieved. In that case, one must have regard to the main purpose of the design. There were no such features here. The transfer to which attention, as I've emphasized, must be focused is the sale from SJA to SJG. That had no features indicating any design for the main purpose of avoiding tax. On this, HMRC in their written case in paragraph 78 state, the phrase designed for the purpose of avoiding liability to taxation encompasses transactions such as the present, which have been conceived, planned, and effected with an intention and main purpose of avoiding UK tax liability, and where there's no other reason for the transaction or any feature of it other than to avoid tax. But this is exactly the point on which the upper tribunal disagreed with the first-tier tribunal. And the upper tribunal reversed the first-tier tribunal, and so it's necessary to see what the upper tribunal said. The upper tribunal's decision is at paragraph 145, electronic page 195. We prefer the appellant's argument. We were the appellants for the upper tribunal. Parliament has legislated for two potential motive defences. The first requires a taxpayer to establish that there was no tax avoidance purpose at all for the relevant transactions. The second, only available where the relevant transactions were bona fide commercial transactions, requires the taxpayer to establish that the transactions were not designed for the purpose of avoidance. As was observed in Carville, it's implicit in this that tax avoidance may result from the transactions, as it did in Bremner, without disqualifying the taxpayer from benefiting from the second limb of the defence. If the FTT's analysis were correct, the existence of any tax avoidance purpose at all would always disqualify a taxpayer from reliance on the second limb of the mode of defence, rendering it pointless and effectively overruling Bremner. This cannot be right. There is a qualitative difference between a situation in which a taxpayer voluntarily enters into a tax avoidance arrangement in order to save tax and a situation in which a taxpayer is effectively forced to restructure in the same tax-efficient way as its competitors in order to secure the survival of the business. And it was on those grounds that the upper tribunal reversed the first-tier tribunal on this second limb. The Court of Appeal, however, at paragraph 90, electronic page 140, considers that the upper tribunal was not correct in what I have just read to you, and that there was a misconception. And it's clear that the upper tribunal considered that the misconception was a grounds for reaching a different conclusion. It's paragraph 90. I can see some of your ladyship reading it. Shall I leave you just to read paragraph 90? It's at electronic page 140. Now, what they disagreed upon was the reasoning of the first-tier tribunal. And that reasoning is at paragraphs 534 and 535. That's electronic page 334. And if I can just read to you from middle of paragraph 535. We doubt whether in examining whether an avoidance purpose was the main purpose, one could go so far as relying on the consequence of a tax avoidance reason. It cannot be the intention of the legislation that someone who looks beyond the tax avoidance to the consequence of that can be allowed to supplant those consequences as their main purpose. If it were, such consequences would virtually always operate to stop a tax avoidance purpose being the main purpose. So the FTT is saying you cannot, we doubt whether, in examining whether an avoidance purpose, you cannot rely upon the consequence of a tax avoidance reason. With respect, the first tier tribunal is incorrect in that approach, and the upper tribunal was correct to disagree. When you are looking to determine what is the main purpose of the design, it is appropriate to look at all factors, both the tax avoidance and the consequences of that, and then to determine what was the main purpose. There may be, it's stated in Carbon, well accepted, there may be more than one purpose. If you ignore the economic consequences, you are left only with tax avoidance. And therefore, as the FTT said, this defense is never available. You have to look at the consequences in order to work out what is the main purpose. Can I take an example?
But aren't you then asking a different question, which is what is the main purpose of avoiding tax, rather than what is the main purpose of the transaction?
No, I think you're not. You're accepting that there is a purpose of avoiding tax, but there is also an economic consequence of that.
Yes,
and you're asking which is the main
reason
purpose.
why you want to avoid tax is to save the business or have more money to do something else. Mm-hmm. But you're not. That's not what you're looking for. You're not looking for the purpose why you want to avoid taxes. You're looking at, was the purpose of the transaction to avoid those taxes and thereby enable you to achieve the longer term goal of saving the business or buying a new factory or whatever?
With respect, you're looking at what is the main purpose. You've got two purposes there. The purpose is to avoid tax, the purpose is to save business. What is the main business and what is the main purpose of the design? If you ignore the economic purpose, then you're left only with the tax avoidance purpose. And as the FTT quite correctly said, that means the defense, as the upper tribunal correctly said, that meant the defense is never available. The upper tribunal are absolutely correct on this point, and with respect, the Court of Appeal was wrong to disagree with them. In order to balance up looking at the purpose of the design, you have to take into account all of the purposes there. Can I give you an example? Suppose that a company is entering into a bona fide commercial transaction, the purchase of equipment with a loan, for example. The transaction is structured, however, so that it generates additional capital allowances, and the company obtains early deduction of costs and ends up saving tax. As a consequence, it can pay off the loan earlier, which is the main purpose of the design. If, as the FTT suggests, you cannot take into account the consequence of the tax saving, that is the early repayment of the loan, then all you are left with is the purpose of saving tax, and you can never rely on the defense. That's what the upper tribunal was saying, that it is important to have regard to the consequences being the saving of the business. That was clearly a purpose. The question is whether it was the main purpose. And with respect, the upper tribunal was correct to reverse the first tier tribunal on that point, and the Court of Appeal was wrong to disagree with them.
I mean, I think for myself, I struggle a little bit with trying to say the saving of the tax or the saving of the business was the main purpose. The two seem to run together and be coextensive. But I was wondering whether you even need to go so far as to say the main purpose was to save the business, because looking at section 741B, the transfer is accepted to be for a bona fide commercial transaction, and then the onus is, if you like, on the revenue to show that it wasn't designed for the purpose of avoiding liability to taxation. So if you've got two purposes, one avoiding taxation, the other saving the business, but they're coextensive, applying Carville, it can't be said that the main purpose is avoidance of taxation. And so if that's the right way of analysing it, wouldn't you then win on section 741B, even if one doesn't get into some sort of obligation to say, no, saving the business was the main purpose, or saving the tax was the main purpose?
The only way you lose on this is if, as the first-tier tribunal wrongly said, you have to disregard the consequences, the economic consequences of the tax saving, and therefore you ignore the saving of the saving of the business, and you're left only with the tax saving. And that's exactly what the upper tribunal says the FTT made an error on. I'm very conscious of the time, and that I promised to leave. I think we will not be able to take the extra time in reply, I'm afraid, and we shall have to go on to 3:30. Otherwise, it's unfair to what I'm afraid have there. I have only some very final comments about Anne Fisher, I will just refer you to the paragraphs that refer to Anne Fisher's inactivity. That's paragraph 21 at electronic page 258, paragraph 199, electronic page 283, paragraph 337, electronic page 336. And that's particularly important because it says Anne Fisher played no active part in the decision making. Paragraph 507, electronic page 330. Paragraph 515, electronic page 331. Paragraph 516, electronic page 321. And that's the point that Anne Fisher did not have a motive. And my only comment there is that Anne Fisher is found to have had no motive, but the motive defence operates by reference to the purpose for the transfer. Consequently, Anne was fixed with a purpose of tax avoidance by the FTT, even though she had no subjective purpose at all. That's a clear example of the unfairness of the operation of the motive defence in the case of a minority shareholder, if it is possible to apply 739, who is inactive. Given the width of the 739 charging provision and the penal consequences, the motive defence, as I've emphasised, is particularly important, but it's unavailable to an inactive person such as Anne. And that unfairness should be avoided. And one answer adopted by the Court of Appeal was to avoid it by concluding that Anne should not be regarded as a quasi-transferor. And that would seem a way to avoid the unfair consequences that she is not otherwise able to rely upon the motive defence, which is so critical to the legislation. If your lordships, ladies, have any other questions?
It doesn't appear so. Thank you very much, Mr. Baker. Mr. Mullen.
I can speak. Oh dear, I knew that was going to... Sorry. You start and I'll mop up. Thank you.
My Lord, my Lady, I propose to address the third issue, which arises in this appeal, and that concerns Anne Fisher alone.
Could you just overlook the
This is the EU law.
This is the EU law point. The reason why it concerns Anne alone is because she is an Irish national. And the question is whether she's a defence to the transfer of assets abroad charge by reason of the fact that through standing in Gibraltar, she, as an Irish national, was exercising the right of establishment, which is guaranteed in Article 49 of the Treaty of the Functioning of the European Union, although strictly, given the periods we're looking at, it's Article 43 of the EC Treaty, but the content is the same and nothing turns on the difference. Now, the first tier tribunal and the upper tribunal both found that the charge was contrary to Anne's right of establishment, and our position is broadly that the first tier tribunal and the upper tribunal were correct on this. The issue, I should say, doesn't arise in relation to Peter or Stephen because, as the Court of Justice held in a reference in this case, for EU law purposes, Gibraltar and the UK are a single member state, and as British nationals, that means that they have a problem with their situation being wholly internal to a single member state, and therefore they are not exercising the right of establishment. Now, although they did try in the courts below to argue that they could benefit from the right of establishment, whether by reason of Gibraltar's status or by reason of relying on Anne's rights, permission on that has been refused, and so I don't address that. Now, in terms of the issues which arise, I have 7 broad points to make. The first point is that we are dealing with EU law, and the purpose of that law was to create an internal market without frontiers. The second is that we're concerned with the charge which applies to the income of a person abroad. The charge is not on the income of a UK resident. It is not a charge which is consistent with the principle of territoriality. And that, as we'll see, is why it's objectionable as a matter of EU law. Third, as a matter of EU law, and in the context of establishments in other member states, it's absolutely clear that the charge under Section 739 is unlawful. It does breach the right to freedom of establishment. In that context, if we were looking at Stan James Malta instead of Stan James Gibraltar, we wouldn't be here. The issue is clear. Fourth, though, that analysis applies even though the charge applies within a region of a member state, because we have a deemed single member state between the UK and Gibraltar. But given that Anne is an Irish national, EU law is engaged, and the UK is restricting Anne's right to establish a business in Gibraltar, and it's doing so by a penal tax charge. And that's the Walloon case, which I've referred to in the case, and I will take the court to. Fifth, it makes no difference that the restriction is affected by reference to tax law rather than social security law or any other area. Six, the HMRC argument that you can have a restriction on freedom of establishment provided you do not discriminate on grounds of nationality is incorrect. It is not made out by the case law, and it's not made out by the case law they cite. In fact, it's contradicted by it. And seventh, contrary to what the Court of Appeal said, there is very clear law that using tax policy to favour one region over another is not permitted under EU law, absent good public policy grounds for doing so. So I propose to address in somewhat more detail those 7 points. Points which I don't propose to address is whether the restriction can be justified by seeking to achieve a legitimate aim, and if so, whether it's proportionate to that aim. The reason being that HMRC don't address that in their case. It's dealt with by the first tier tribunal at paragraphs 652 to 670, and by the upper tribunal at paragraphs 174 to 179. And in our written case at 142 to 145. Similarly, on the question of giving effect to Anne's EU law rights, we rely on what the first tier tribunal and the upper tribunal said, as set out at paragraph 146 of our written case. So taking us then to the first point, that we are dealing with EU law. The provision we're concerned with is Article 49 of the Treaty of the Functioning of the European Union. The relevant part of that states that within the, sorry, I should give you the reference to that. It's in the Authority 3 at page 1162. And the relevant part of it states that within the framework of the provisions set out below, restrictions on the freedom of establishment of nationals of a member state in the territory of another member state shall be prohibited. And we are, of course, dealing with a national of one member state, Ireland, in the territory of another member state, the UK. Now, a point to make about that text is that there is nothing in that to suggest an additional requirement of discrimination on grounds of nationality, which is central to HMRC's case. The next point in that respect to note is that the approach to construing EU law is not the same as construing a UK statute. There is an emphasis on adopting an interpretation which ensures that the legislation fulfills its purpose, which then brings us to the question of, well, what is the purpose of these provisions that we're looking at? What is the purpose of Article 49? And the answer of that can be found in Article 26 of the treaty, which is at page 1972, tab 47 of the bundle. And we can see it, paragraph 2, it's about creating an internal market, and the internal market shall comprise an area without internal frontiers in which the free movement of goods, persons, services and capital is ensured in accordance with the provisions of the treaty. And what we say is that the correct approach to interpretation is one which achieves that purpose. Because we're dealing with this in this slightly unusual situation where the restriction is affected by where the mainland UK in relation to another region of the UK, it's a slightly odd one. But when we focus on what it is that the restriction on the right of establishment is trying to achieve, what we can see from all the cases, and no matter the context, it's about creating an internal market without frontiers. And that's obviously very relevant when we look at the approach which HMRC are urging. That would have the effect that Article 49 is not effective to achieve its purpose. What they are suggesting is that we read words and limitations into Article 49 in order to create a frontier, in order to create a limit on the right of establishment. And to that extent, that approach is, I'd submit, counterpurposive. HMRC also suggests that, well, when you look at the case law, we rely on the Cadbury-Schweppes case, which we'll go to. It cannot apply because Gibraltar is, in fact, the same member state as the UK, whereas that which Cadbury-Schweppes was looking at the UK restricting an establishment in Ireland. That, with respect, misses the point. Article 49 is there to confer rights, and what Cadbury-Schweppes and all the other cases show is that Section 739, the charge under it, interferes with those rights. And what you cannot do is say, well, it's a slightly different context, so the article no longer achieves its purpose. That, as I say, would be counterpurposive. And put very simply, Anne is a national of one member state who exercised a right of establishment in another member state, the UK, and she is, as such, squarely within the wording and the purpose of Article 49. She exercised those rights when she established Stan James Abingdon. She did it again when Stan James Gibraltar was established, but there was a big difference in the taxation of the two. And she was restricted in exercising the right in relation to Stan James Gibraltar because she was taxed on its income as it arose, and was taxed until she had to dispose of her interest in that company. And that charge applied as long as she wanted to keep living in England. On any view, this rendered the exercise of her rights less attractive, and for that reason it's prohibited under EU law.
In what sense is she exercising her freedom of establishment if, as you say, she doesn't actually do anything about the business?
Well, the case is put both in relation to the right of establishment and right to free movement of capital, and it ultimately doesn't matter which we rely on. The reason why we say the right of establishment is exercised is because of her shareholding in the Gibraltar company, which is such as to give her an influence over that company. And in terms of the way in which the Court of Justice has approached these cases, having a shareholding of that size would generally be equated to the exercise of a right of establishment. But I fully accept on the facts, she wasn't doing a whole lot in terms of running Stan James Gibraltar. She was a shareholder. But if that were an issue, the answer would be, let's look at the free movement of capital. Indeed, the first tier tribunal, when it looked at it, addressed everything by reference to the right to freedom of establishment, and then concluded the same follows in relation to free movement of capital. But the way the arguments have developed, it's tended to be argued by reference to the right of establishment. I don't think it makes any difference in terms of principle which of the two treaty freedoms we rely on. That does take me to my second point relating to the nature of the charge. And I want to emphasise this point because it's important to understand what this charge is doing. And sometimes, certainly reading the Revenue's written case, it seems a bit confused as to that. Anne is not being charged on her income. She's been charged on the income of Stan James Gibraltar. The analysis which would apply if Anne were being taxed on her own income is very, very different from an EU law perspective, and it's unhelpful to confuse the two situations. And that's because EU law has no problem with taxation in accordance with the principle of territoriality. States can tax a residence on their worldwide income, and generally do, but crucially, that's taxing them on their worldwide income, not somebody else's income. What's happening here is that Anne isn't being taxed on her income, she's being taxed on somebody else's. Obviously, you can also have tax based on income as a source in the state, and again, there's no problem with that. And the court even recognises a justification based on this, the so-called balanced allocation of taxation justification, where you have a restriction, but it's designed to ensure that a member state can tax activities in its own territories. That is justified, and that's something which is built into the case law of the Court of Justice. But that justification, isn't in point here because of what this legislation is doing. It's not taxing Anne on her income. It's not seeking to tax activities in the UK. It's seeking to tax the income of a person abroad on activities which will typically be outside the UK, here in Gibraltar, but obviously the legislation applies elsewhere. And the interaction of taxing systems operating in their, if I may call it, the normal fashion, and the reason why they don't cause a problem with EU law is what Advocate General Hilhoud was explaining in the test claimants in the ACT group litigation case, which is a passage referred to by Lord Justice Newey at paragraphs 99 to 101 of the Court of Appeal judgment. That's in the key documents at 143 or the hearing bundle at 263. And we discussed that at paragraphs 138 and 139 of our written case.
And sorry, what's the bundle reference to the Advocate General?
To the Advocate General is Authorities 82 at 2940.
Thank you.
But while it's all very interesting, it's actually irrelevant to the charge which we're looking at here. Because what that's looking at is how different states with their territorial taxation systems, how they interact and how that can create friction, because on the one hand you've got two states which may have different tax rates, and that may on the one hand discourage moving from one to the other. On the other hand, it may encourage moving to a lower tax rate. But ultimately, what the Advocate General is saying is, from an EU law perspective, that doesn't cause a problem. The reason why the transfer of assets charge does cause a problem is because, as I say, it's imposing a tax charge not because you've got income, but because you've got power to enjoy the income of somebody else. And that's very much an exception to the general approach to taxing worldwide income. And obviously the person abroad is not resident in the UK. If they were, they wouldn't be a person abroad. The person who's taxed is, of course, a resident, but they have no income, and they're taxable whether they receive it or not. And the reason why all this is important is because it's a gross oversimplification to say that we're concerned here with the UK's right to tax its residents. We're not. We're concerned here with the charge where the UK is seeking to tax non-residents. And I'd also say that if this was simply a case of the Gibraltar government imposing a higher corporation tax rate, then there'd be no problem, there'd be no issue. But this isn't a charge coming from the Gibraltar government. This is a charge coming from the UK government.
They're not taxing non-residents, but they're taxing the income of non-residents in the hands of the UK residents.
Absolutely. But the income which the charge is focused in on belongs to the non-resident.
But that non-resident doesn't have to pay a penny under these UK tax provisions to the UK.
Not under these provisions. But of course, if a benefit was provided or if dividends were paid out of Stan James Gibraltar to its shareholders who are UK residents, that would be their income,
Yes.
and that would be taxable. The third point I wanted to address is the case law on
But
why
you
these...
accept that in that circumstance it wouldn't make any difference whether Anne was a UK national or an Irish national?
It wouldn't make any difference whether Stan James Gibraltar was based in Gibraltar or Malta, as I say, because that's not something which is a restriction on the right of establishment. That's just a normal function of a state exercising its taxing functions to tax the income of its residents. Now, as I say, the third point I wanted to look at is the case law on why charges on a non-resident's income of this type are problematic. We deal with this at paragraphs 120 to 123 of our case, and the main focus, as it was in the first tier tribunal, is the Court of Justice decision in Cadbury Schweppes, which is to be found at tab 17, 2558 of the authorities bundle.
Could you give me the page number again?
At 2558.
2558, thank you.
Now, the case involved...
That's FII group test claimants.
Oh, I do apologise.
2558.
Let me just double check that then. Sorry, 1558. Now, the case involved the UK Controlled Foreign Companies legislation. The obvious parallel is that that legislation taxed a company on the income of its subsidiary if that subsidiary was based in a low tax jurisdiction. So here, a UK company was taxed on the income of its Irish subsidiary as that income arose. The parallel to the Section 739 charge is that we have a tax charge on a UK resident on the income of a non-resident on an arising basis, and in each case, if the company invested in its UK resident, there would be no tax charge. The case is central. I don't propose to read through it, but if I could just make 5 points in relation to...
So here, when it's talking about a low tax country, that's talking about a different member state.
It is talking about a different member state. But my lady, in this point, I want to just address the case law which establishes that these sorts of tax charges which tax a UK resident on the income of another person are contrary to EU law, and it's very well established, and the reasons for that. I will then go on to look at the position where it's happening within the single member state and why, even in that situation, the restriction on the right of establishment is prohibited. So the first point I want to make is that although the court makes the point that direct taxation falls within the competence of member states, and they must nevertheless exercise that competence consistently with EU law, and that's something which is trotted out in most of these cases, and it's not controversial. This was an example of the UK exercising its taxing competence inconsistently with EU law. And for that reason, even though the UK has competence in relation to taxation matters, nevertheless, the court interfered. The second point is the reason why the legislation restricted the right of freedom of establishment was because it created a disadvantage for UK resident companies with a subsidiary subject to lower tax in another member state as compared to those with a subsidiary in the UK. That was paragraphs 43 to 46.
And what page is that, sorry?
That is page 1725. Yeah. Now, on this point, one of the questions which the Special Commissioners had raised on the reference concerned whether the correct approach was to consider a restriction or whether it was to consider discrimination. And you see that point being raised at paragraph 24. Well, the court recognising that point was raised at paragraph 24. And now, the Court of Appeal didn't address this directly, but its analysis was that the legislation did create a restriction. Interestingly, Advocate General Leger Paragraph 63 of his opinion does address it. That's on page 1574. And what he says is that in its more recent case law, the court does not inquire into whether a measure in question is to be classed as direct or indirect discrimination. And you see that between B and C on page 1574. So in the context of that case, although the question was asked about discrimination, it wasn't answered directly, but the Advocate General says no, and the court addresses restrictions. The third point is that the court concluded that it wasn't an abuse to exercise the right of freedom of establishment in order to benefit from a lower tax rate, and that's at 34 to 38 if it's a reasoning. Page 1592. And in line with that, the need to prevent a reduction in tax revenue will not justify a restriction on a freedom introduced by the treaty, and that was said at paragraph 49 on page 1594.
I'm sorry, I missed that. I didn't get a note of the point you were making about paragraph 49.
The court says that the need to prevent a reduction in tax revenue, that doesn't justify restricting the right to freedom of establishment.
Right.
You can't say, we're not going to let people transfer assets abroad because we'll collect less tax that way.
So here, the UK tax regime was set up in a way which acted as a disincentive to companies considering establishing subsidiaries in member states with lower tax rates than the UK.
Yes.
Yeah, so that's an obvious breach of Article 49.
Oh, well, absolutely. And what we say is the parallel with Section 739 is very clear. And again, it's an obvious breach of Article 49.
Maybe not quite so obvious. You need to take us through it.
Certainly. Well, I think just to finish off the points in Cadbury Sweps. Sorry, my lord, I am, of course, talking here about the situation where rather than setting up Stan James Gibraltar in Gibraltar, if you'd set it up in another member state, then the parallels to Cadbury Sweps would be undeniable.
Yeah.
What they then go on to say at paragraph 65 is that the charge couldn't apply where the incorporation of the company abroad reflects economic reality. And we, of course, had a finding by the First Tier Tribunal that Stan James Gibraltar did reflect economic reality.
But presumably this 739 provision has often been used to tax UK residents on income arising from assets which they've transferred to another member state.
Yes. And our point is that that is a breach.
Right, but nobody's ever established that that's a breach of Article 49. I mean, that would be a breach of Article 49 for a UK resident, regardless of whether they'd come from a different member state.
Yes, it would be a very clear breach. The reason why there's an issue at all in this case is because we're looking at Gibraltar.
Yeah.
Mm-hmm.
But is there a case which establishes that the way that Section 739 usually operates, which is not for Gibraltar, is inconsistent with Article 49?
There's not a case directly on it. What I would say is that the European Commission did bring infringement proceedings against the UK in relation to the Section 739 charge.
Yes.
What the UK did in response to that was to introduce a defence which postdates the facts we're dealing with, a defence which effectively says that the charge doesn't apply where you're exercising EU law rights, and that's in Section 742A of the Income Tax Act now. So that was an acknowledgement that there is an issue with the Section 739 charge, or 720 as it later became, and EU law. And with respect, it's unarguable that there's not an issue with it when one looks at this case law.
So effectively, Section 739 now only operates as regards Gibraltar or other tax places which are part of the UK.
Well, that is one of the oddities, that the Fishers seem to have picked one of the very few places in the world where they couldn't rely on an EU law defence. Of course, freedom of establishment only applies in relation to establishments in other member states, and so is relatively restricted in that way. Free movement of capital does apply in relation to third countries, but there are other restrictions there. For example, there's a standstill provision which says if you had something in place at the end of December 1993, I think it is, then that restriction can continue to apply. But certainly, there is an ongoing problem in relation to it. This isn't the only case in which it's been raised, but it is the first where the courts have fully considered it. The other case which I mentioned in the case was a case called the European Commission and the United Kingdom, which is at the Authority 66, page 2514. That was a case which was brought as a result of infringement proceedings in relation to Section 13, which is Section 13 of the Taxation of Chargeable Gains Act, which is a slightly parallel provision which applies in relation to capital gains tax. And again, you just see the same analysis there. And again, you see the same analysis in a more recent case, a case from Germany called X, intermediate companies established in third countries, and that's at page 3088 of the bundle. And that was decided in February 2019. And at paragraph 57 on page 3097, you see the court affirming the analysis in Cadbury Schweppes. I should say that case involved a subsidiary based in Switzerland, which isn't a member state, and so the context was free movement of capital. A lot of the analysis of the court is around the standstill provision in Article 64 and whether that applied or not. It does then go on to consider free movement of capital. One of the points is the correct comparator, which it identifies whenever you're considering is there any sort of arbitrary discrimination. And what they say is that once Germany, in that case, decided to tax the income of the Swiss company, then the situation of the Swiss company and a German resident company became comparable, and given the difference in treatment, that was capable of amounting to arbitrary discrimination unless justified by an overriding reason in the public interest. And that's page 3098 at paragraphs 62 and 67. And the reason why they had to consider that additional point was because of a slight difference in the way in which the articles around free movement of capital are worded, in particular Article 65. But what it does show is the correct comparator if you're considering discrimination in this context. And that is not Peter and Stephen. That is, in the context of facts we've seen, for example, Stan James Abingdon. Anne is taxed very differently on the profits of Stan James Abingdon than she is on the profits of Stan James Gibraltar. And that difference in treatment has the effect of restricting her right of establishment.
She's taxed in the same way as Stephen and Peter are.
She is, but they are not, and this is what I say comes from the X case, they're not the relevant comparator. So having addressed the position on the sort of normal other member state type situation, it is of course relevant to look at, well, how does this apply to Gibraltar when we have a single member state? Now, I'd say the position in the courts below were more complicated, or the arguments, I should say, were more complicated because of Stephen and Peter's position. We did have a reasoned order from the Court of Justice in this case, where they said that for EU law purposes, Gibraltar and the UK are treated as a single member state. They were very clear that that was the only question they were addressing. But they went on to say that the exercise of a freedom of establishment or free movement of capital by British nationals between the UK and Gibraltar is a situation confined in all respects within a member state. And they did make a reference to British nationals. That wasn't a reference which was found in the prior Gibraltar Betting and Gaming Association case. But that's what the problem for Peter and Stephen was. In relation to Anne, we say the position is governed by the Walloon case. Sorry, I should say there's a point made in the Revenue's case about our describing Gibraltar as a region of a member state. It's not a new argument, as it was put. The only point there is that if the UK and Gibraltar are deemed to be a single member state for EU law purposes, then applying that deeming, Gibraltar is a geographical region of that single member state. And we say no more than that, and clearly that must be the case. There's a different law applies within that part of the deemed member state. And I don't entirely understand the point that's made about it, but that's all we say about there being a region. The central case on this is...
I was wondering how far you take this. Does this mean, for example, regional development grants might be a breach of Article 49? You know, if you set up your factory in a particular part of the UK where there are financial advantages available to you, rather than setting it up in I don't know, southeast of England, where there are no such financial incentives available, would that engage Article 49?
Well, I think on one hand it might do, but I think the answer would probably be that any issue with Article 49 was clearly justified for public policy reasons, and that's the reason why you have the regional grant. I do deal with that sort of in the last point about state aid and different areas, because one of the points which the Court of Appeal had said was, well, you can have different rates wherever you want within a member state, but the state aid case law is quite clear that you can't unless you're dealing with effectively autonomous regions. So Gibraltar would be an autonomous region.
This isn't a state aid, no.
It's not, but if one's talking about EU law, you would expect it to apply consistently. And saying, well, EU law has no problem with that, it's frankly contradicted by that case law. In terms of the Walloon case, the point is that the court identified two classes of people: Belgians who'd never left Belgium. Their situation was wholly internal. That was paragraph 32.
Sorry, page?
Page 1723. And then you had foreign nationals and people who had left Belgium. And effectively, that second category were exercising the right to freedom of establishment. And the core of the reasoning as to why there is a restriction is that paragraphs 48 to 50 on page 1726. And the problem was that if you lived elsewhere in Belgium but worked in the relevant regions, you didn't qualify for the care insurance scheme. If you lived in the relevant region, you did. And in fact, if you lived in another member state and worked in that region, you did qualify. And what the court says at 48 is the fact that employed or self-employed workers find themselves in a situation in which they suffer either the loss of eligibility care insurance or a limitation of the place to which they transfer their residence is at the very least capable of impeding the right to exercise of the rights conferred by Article 39, 43 and 43. And that very much describes the situation Anne found herself in. She suffered either higher taxes or a limitation on where to live.
Let's take a little bit fast for me. Paragraph 48 begins with the words migrant workers. So is this concerned with workers from other member states who are pursuing or contemplating the pursuit of employment or self-employment in the relevant regions of Belgium?
It's concerned with as the category which they identify in 34. Any national of a member state. Sorry, no. The category of people who have exercised rights of free movement, yeah, and or foreign nationals, and then it's considering in 48, well, why would that be an impingement on them? Because, well, if you were a worker and you wanted to move, and you're considering where to move, it's a disincentive to live elsewhere in Belgium if you're working in the Dutch-speaking region.
Right.
And ultimately, we say that applies in this case.
Exactly how?
Because what they are saying is that when you have exercised your rights and it is less attractive to you to live in one part of the member state than the other, then that is a disincentive on exercising those rights in the way in which you want to. That disincentive is a restriction on the right. It breaches the right which you have exercised under Article 49 and is unlawful for that reason.
So people in other
effect, you have to become a resident. You have to leave your UK residence.
Yes, so Anne Fisher, she was effectively faced with either get rid of her shares or move to Gibraltar or indeed move to Ireland or elsewhere. But she was disincentivized from remaining where she lived in England.
So this is saying, this Walloon case, that if you're somebody outside Belgium and you're thinking of where to move to in Belgium, it's more attractive to move to one part of Belgium than another part of Belgium, and because of that, your freedom of establishment is being infringed.
Yeah, so your right to establishment being exercised here is your right to go and work as a self-employed person in the Dutch region. Now, the Dutch
region of Belgium.
The Dutch region of Belgium, that was the region which had the care insurance scheme.
But do you have a right of freedom of establishment in a particular part of a member state? Or
yes,
just a right to go and establish yourself in that member state?
Well, I think, well, what I'd say is the right applies to the entire member state, and it applies to individual regions within that member state, because what a state can't do is say, you can exercise your rights in England, but you can't exercise it in Scotland or Northern Ireland because we don't want people from France going there. That would obviously be a breach or an infringement on the right of establishment. The right of establishment applies to the entire member state, and it applies to it in a uniform manner. And what we're saying here is that Anne was entitled to exercise her right of establishment not only in England, where she established St James Abingdon, but also in Gibraltar, where she established St James Gibraltar. But when she did that, she was effectively penalised for it.
So what the outcome of this Walloon case is that if you're a German person or a Spanish person, when you decide you want to go and live in the Dutch-speaking region, you can insist that you have the rights that apply to a person in the Brussels capital region applied to you.
I think, it's the Dutch-speaking and the Brussels capital region where
they have the same system.
Yeah, the same system.
It's the Walloon, the French-speaking system that has a different regime.
So what I'm saying is that
the outcome of it then?
Sorry?
So how do they have to treat that person then?
Well, they have to, because despite the fact that they are living in the Walloon region, the fact that they are working in the, if you just say the Dutch-speaking region for simplicity, means that they're exercising a right of establishment there. But they are disincentivized in the way they do that, because by living in the Walloon region, they don't qualify for the care insurance scheme. And so what the court is saying, well, is that no, that's an unlawful restriction. You have to apply the care insurance scheme effectively to everybody who works within the Dutch-speaking region.
Well, only people who are nationals of other member states.
Oh, sorry, yes. You didn't have to apply it to Belgians who'd never left Belgium.
So you have to give migrant workers coming in and Belgians who have left Belgium, you have to give them these rights, which
Yes.
fellow Belgian citizens don't have.
Yes, but notably, it's not an answer to say there's no discrimination here because the Belgians who don't have those rights, they can't rely on EU law, therefore they don't have those rights. You're being treated the same as them, no problem. And that's the revenues argument here. And now, if that was right, then there wouldn't have been an issue in this case because they could say, well, they're wholly internal, you're treated the same as them, there is no discrimination. But that's not what the court does. The court says they're wholly internal, so we can't deal with them. And then the people who are exercising rights, they say, well, your rights are restricted, and you can benefit from those rights.
Yeah. This is a case about free movement of workers, isn't it?
It is, but that obviously engages both Article 39 and the right to freedom of establishment because
And
working as a self-employed person.
Paragraph 47 explains that the legislation produces restrictive effects on freedom of movement inasmuch as it makes affiliation to the care insurance scheme dependent on the condition of residence in a limited part of the national territory.
Yes, and that's very much why we say there's a problem here.
Yeah.
There's a restriction.
Well, I think one can understand that. I mean, it'd be saying effectively, if you're a foreign national and you're thinking about going to work in Belgium, in order to qualify for the maximum social security benefits you've got to go and work in a particular part of Belgium.
Not just work there, but also live there.
Yeah.
My Lords, my Lady, I'm conscious of the time. I think I've used up my time. If I can briefly direct you to just a few points in relation to the remaining arguments. I mentioned the revenue case law on discrimination not being consistent with what they relied on. At footnote 20, they refer to a case called Mobistar at Authorities 75-2730. My submission is that doesn't support what they say it does at all. In fact, it goes the other way. In relation to whether tax is special, all I'd say is it can't honestly be the case that if instead of imposing an income tax charge on Anne Fisher, what the UK had done is said, well, you're going to lose your social security benefits, that she would be exercising EU law rights in that case, but not in this one. I'd also note that, just to give you a reference to the Advocate General in the Schumacher case, he deals with this at paragraphs 15 to 32, and that's on page 1625, paragraph 30 in particular, where he basically disabuses the tax is different argument. The point on the state aid cases is broadly that those cases say that a central government can't distinguish between its regions and applying a tax system, but the individual regions can. Here we have a tax charge coming from the central government. And so with that, unless there are any further questions, that completes my submissions on these points.
Thank you very much. Thank you very much, Mr. Mullen. Yes, Mr. Baker.
May I just give you the references to the Vesti cases that were provided to you, the paragraphs that appear to be relevant, the pages that are relevant in the two cases that were sent to you at the magistrate are Vesti 1, 184F to 185C, and Vesti 2, page 202, D to F.
Thank you very much, Mr. Baker. Mr. Hewitt.
Good afternoon. I hope I'm right in between the microphones. I apologise if my voice is a little bit As regards the Vesti decisions that you've been handed. I'll have a look at them overnight. And my recollection was that broadly Mr. Justice Walton was bound obviously by Congreve at that stage. What he did was find some rather imaginative ways of getting round that by construing Section 739. And I think it's right to say that Lord Wilberforce rejected all of these when the case went to the House of Lords, but they were no longer necessary. In presenting our appeal, I shall be dealing with the multiple transferor point, and then the motor defence question. And my learned friend, Mr. McGirt, will be dealing with the EU law matters tomorrow. Can I begin then with multiple transferors? And the way I intend to develop our case is as follows. I would like first to go to the heart of the Fishers' positive case by reference to particularly paragraph 26 of their written case, which I think summarises the steps in their argument. Having listened to my learned friend this morning, I think his arguments very much reflect what is said in paragraph 26. I shall then turn to section 739 itself and look at the statutory provision. I don't think you've actually been taken to section 739 yet. And I shall deal with what we say is the proper construction of that provision. And most importantly, I shall be submitting that the focus must be on construing and applying section 739 as it stood at the relevant time.
Well, that's one of the things I was going to ask you about. We've got a multiplicity of versions of the legislation as enforced at different dates.
Yes.
It would be helpful for us to have some assistance in knowing which versions we should be looking at.
Yes. Well,
at some point.
Yes. The simple answer I would give you is you should be looking at the version in force on the relevant dates when the income arose in this case. And that's the version which is in the authorities bundle at the very beginning. And this is important because although the 1988 Act was a consolidation act, and in normal circumstances, one would quite readily look back to authorities on the prior versions of the Act. So, for instance, normally the 1970 Act would be in almost identical form to the 1988 Act, and indeed the 1952 Act. But in this case, there are important, very important differences between the 1970 Act and the 1988 Act, particularly in two respects. One is Section 744 is now part of the code. And secondly, subsection 1 capital A was part of Section 739 at the time in question.
The second point was section?
Subsection 1 capital A.
Yes.
Which you've been shown, but I don't think perhaps the full importance of that provision has come out. So we say that you should be looking at the form, the legislation in force in the 2000s, which is the relevant time. And that would be the starting and the finishing point, and applying that legislation. Farrell and Alexander and other cases following that make it clear that it's not appropriate normally to engage in a form of archaeology, looking at previous versions of legislation and attempting to deduce from cases on that previous version what the true construction is of the current legislation. And we say very much that is what the Fishers have been doing to a certain extent in this case. I am going to be looking at the prior authorities, Congreve, Majesty, and Willoughby and McGuckian, but I would draw attention to the fact that all of these authorities, bar one, bar Willoughby, were all decided under the previous version of the legislation without Section 744 being present. So they were all decided in the situation where there was no apportionment provision in the legislative scheme to apportion between potential persons who have charged. Willoughby was decided after that, but my submission will be the entire reasoning of Willoughby on the particular point in question has been reversed by subsection 1, capital A. It's a very unusual provision because it reverses a previous decision, but not by simply stating that the law is different, but actually by reversing the reasoning in the case, which was that you couldn't draw an inference from a particular part of Section 739, if you remember. I mean, I'll come back to this, but it's quite unusual. There are two unusual features to this case statutorily. The other one is that this section, I don't know whether it's unique, but I certainly haven't come across it otherwise, contains a preamble. Yeah. And that is pretty unusual in legislation. You will have seen, perhaps, looking at Section 36, that originally it was a true preamble. It wasn't actually one of the subsections. It is now subsection 1 of Section 739, but it's the same provision. So my submission is going to be that we have to look at that provision. And I'm going to take you to some things said in Benyon. I think my Lord Sales has actually said something about this in a previous case called Eclipse, where he was talking about whether you should be looking back at previous legislation.
There's a bit of a history of this, which for the uninitiated might want to be brought up to date with. There's Lady Arden was critical of Lord Sales's comments in Eclipse in a later case, and I think
Derry.
Others amongst us were critical of Lady Arden's dicta in yet another case.
Yes. Yes, I think that's right. I think the problem arises when you're looking at decided authorities on prior versions of the legislation. And I think some people had read some of the things that Lord Sales perhaps said and others said as suggesting that you just junk all of that prior authority. So, for instance, we have 100 years of authority on what's meant by capital and income. Are you really going to junk all of that because we've got a new consolidation? Equally, we've got a lot of case law on what is an emolument from employment, going back 100 years. Are you really going to junk all of that? And the answer, I would submit, is no. But that's because the legislation is materially in the same form as it was when the prior authorities were decided. That's not the case here. There are important distinctions between the legislation then and now. So my submission will be we have to look at the legislation and construe it.
I think that there are dicta about this in the Lewisham case as well, aren't there?
Yes. I think that's in the bundle, I think, yes. Yes, I think the case you're referring to is a case called Derry, in which as I recall, Lord Carnwath said something about it.
Yes.
In the main judgment, and then Lady Arden said something slightly different in a.
Yeah.
I'm not sure it was a dissenting or a concurring judgment.
Well, I think it's a sort of freestanding judgment that goes a bit of a tangent to the.
Yes. Yeah. Yeah. Anyway, I shall come back to that. I'm then going to set out our positive case on this issue, and then finally I'm going to deal with the problems which the Fishers say arise from the Revenue's case, and indeed the decision of the Court of Appeal. Can I just say something briefly now, and I'll come back to it, about Section 740, because this is clearly an important point. My learned friend said, you don't have to worry about the problems of Section 739 if, for instance, one individual who controls a company but only has a 60% or a 51% shareholding is going to be charged on the whole of the income of the non-resident. And I'll come back to why that would be the case on the Fishers, pieces of the Fishers' arguments. But he says you don't have to worry about that because they'll be charged anyway under Section 740 if they receive benefits. and that will replace the charge under Section 739. The problem is that's not necessarily correct. And I shall return to why this is the case, but you can have a situation where if there was only one transferor who held, let's say, 51% of the shares, they could be charged on the entire income of a non-resident in year 1, and then a benefit be provided in, let's say, year 3 to another beneficiary, and that beneficiary would receive it tax-free because the income would already have been charged on the I'm using inverted commas, the transferor, who only holds 51% of the shares, and that would be, in my submission, a wholly arbitrary and absurd result. I'll also come back to this, but you have to also remember the motive defence.
The 51% shareholder could be charged for the whole amount.
Yes.
If there are no other residents in the United Kingdom,
if he
would be charged for the full amount.
Can I just be clear on this? If you posit a situation where you have a UK company owned 51%, 49%,
yes,
and the controlling shareholder engineers, or the two shareholders together, engineer a transfer to a non-resident company, which is also held 51, 49%. The result of the Fishers case, and I think they accept this, is that and all the other conditions are satisfied as a tax avoidance purpose, etc. The 51% shareholder would be the only transferor on the Fishers case, and therefore he would be charged on the entire income of the non-resident company.
But assume for one moment that the 49% holder in the foreign company wasn't resident. The 51% holder was resident.
Yes.
And he would then be charged for the full amount of tax.
He would be, yes.
Yeah.
Yeah.
Which is a slightly arbitrary outcome.
It is. It's even more arbitrary because if in year 3 the 49% shareholder were to receive a substantial benefit from the company out of that income, he wouldn't be charged at all.
So the sharing in Section 744 that doesn't help at all.
It doesn't help on the 739 charge because there is only one person who can be charged. Take you to 744. This is quite an important point, actually. If you look at Section 744, which is on page 1075, and it's subsection 1, and it's the second after the semicolon in subsection 1, where there is a choice as to the persons in relation to whom any amount of income can be so taken into account, then it shall be taken into account, etc. Well, there would be no choice in this example. It would all go to the one person. Now, it is true that if the 49% shareholder received his benefit in year 1, in the same year, then there would be a choice under Section 739 or Section 740.
Provided that the 49% holder was resident in the...
Precisely, he was resident, yes, exactly, yeah. If he was resident.
So if you only got one resident and you've got multiple shareholders, then the one resident picks up the tab for the lot.
The entire tab.
And he doesn't have to be a 51% shareholder on your case. He's only got to be a 5% shareholder. He picks up 100%.
No, on our case, he would only pick up 5%.
No,
because there would be other
residents, all the other shareholders wouldn't be resident in the...
No, but they would be transferors. They just wouldn't be charged under because they wouldn't be resident. But the apportionment would apply, as it did in this case. If you recall, the reason why only 76% of the income has been apportioned is because one of the shareholders was non-resident, Diane. And so she is one of the transferors, but she's not resident in the UK, so she can't be charged under 739.
But if there's only one resident in the United Kingdom, there will be no choice as to the persons in relation to whom any amount of income can be so taken into account. And so if you have just one resident...
well, I think we disagree with that.
I think your position is...
It can be taken into account.
If there's one resident and he owns 25% of the shareholding, the revenue forgoes the 75% for the non-residents and apportions 25 to him.
Well,
is that how it works?
we would actually be apportioning it between them all, but only the resident would be charged.
That's what I mean.
Yes.
But that's under section 7.4, is it?
Under so forth.
And whereabouts do we get that?
Well, because there would be a choice as to the persons in relation to whom any amount of income can be taken into account. It doesn't say charged, it's
Right.
taken into account.
Right.
So it will be taken into account in relation to all of them, but because of their shareholdings. But the non-residents wouldn't be charged because they're not ordinarily resident in the UK at the time the income arises.
Why does it make any difference whether it's in year 1 or year 3? Isn't this assessed year on year? Or if you decide that one person is the only person who's the transferor in year 1 and there are no non-transferors, that's then set for all time?
No, because even if there was only one transferor, let's imagine there is only one person who transfers. Take a simple example. There's a single transferor who transfers securities to a non-resident company. And income arises. They would be charged on all of the income. However, if a benefit was provided in the same year to a resident shareholder, to a resident beneficiary, let's say of a trust or something, out of that, then there would have to be an apportionment under section 744, because it can apportion charging tax under the provisions of 739 and 740, so it apportions between that.
I thought you were making a point about some benefit occurring in some later year.
Yes, that's different, yes. If it arises in the same year, in year 1, then there is an apportionment because you have to apportion it in that year.
Yes.
But if it has all arisen in year 1 and been charged in year 1 on the transferor, in year 3 there's no further apportionment necessary because there's no more income to be charged. The income has been charged in year 1. You can't readjust year 1.
No, but if in year 3 more income was generated...
No, I'm assuming there's no more income.
Oh, I see.
I'm assuming that there's no more income. Income arose in year 1, charged on the transferor under 739. Now, that could be relevant income because it would be carried forward, but it wouldn't be charged on the recipient of the benefit. And that would be because of the first part of subsection 1. No amount of income can be taken into account more than once in charging tax under the provisions of 739.
No, you've already taxed it, and if the person who was charged decides to give some of that money to somebody else, that's their business. It's not income.
No, they're not giving it. So I think we're misunderstanding. The income arises to the non-resident. Yeah, in year 1. It's charged on the transferor in year 1. It stays with the non-resident, doesn't move, but it's charged. In year 3, a benefit is provided out of that income to someone else.
Out of what income?
The original income, which is held by the non-resident. Perhaps we need to look at 740.
Oh, I see. And some
740
of that is
deals
brought within the jurisdictions.
and it's transferred in cash to a UK resident. Yes.
From the non-resident, non-transferor.
From the non-resident transferee. From the company that has the money. The 740 charges benefits which come out of...
Well, there are two transfers. There's one of the initial asset. It's not that transfer.
No.
It's the transfer of the income earned by the foreign company.
By way of a benefit.
By way of a benefit.
It could be allowing them to live in a property. It could be an interest-free loan, all sorts of benefits. Or it could just be cash. Section 740 charges benefits provided out of the income. Perhaps we could defer this until we look at section 740. But
it might be helpful if we began at section 739. Actually.
Yeah. Yes.
I'd find that helpful.
Yeah. So let's look at 739. And I think I probably just have time to deal with.
Is the right version the 1039?
1039. Yeah.
Okay. So the charging provisions here are subsections 2 and 3.
They are, but we have to look at subsection 1 first. And the first point is the opening words, subject to section 7474B. Now that's a reference to the controlled foreign company legislation, which you were taken to because it was in Cadbury-Schweppes, in fact. And there is a very good summary of that in Cadbury-Schweppes, beginning on page 1563 by the Advocate General, which summarises how the CFC legislation works. Broadly, what it's looking at is a UK company which controls a foreign company in a jurisdiction which has lower tax.
And is that relevant in this case?
It is, yes. It's going to be relevant because I'm going to explain why. In many cases involving large companies, which is one of the points that Lord Justice Phillips makes, in fact, 747 would apply and not 739. And 7474B provides that where the CFC provisions apply, 739 is disapplied.
Is that legislation that Lord Hodge and I had to deal with in a case which you were in about a year ago? Or if you don't remember. Anyway. Okay.
Possible. What it does is it's dealing with a case where there's a UK resident company which controls a non-resident company which is resident in a lower tax jurisdiction.
So these were the provisions that were brought in after Cadbury-Schweppes, were they?
No, these are the provisions that Cadbury-Schweppes was concerned with.
Sorry, Cadbury-Schweppes was concerned.
Yes, it was concerned with the legality of these provisions under EU law. Yeah. But I'm just referring to it because there's a very good summary of the actual UK tax provisions in the Advocate General's opinion. So you have that situation. The foreign company makes income, and that is attributed to the UK company that controls it and charged to corporation tax on that UK company. And there are various conditions that have to be satisfied. One of them is a form of motive defence. Broadly, we're not exactly the same as the 739 defence. And that was in fact the subject of Cadbury-Schweppes. That was why that was a case I was involved in. Cadbury-Schweppes, the reason that there was the argument was because of the motive defence in the UK legislation. The question was whether that meant it was compatible with EU law. And I think it was held no, it had to go a bit further than that. But in any case, the reason for these opening words is to draw attention to the fact that if you have a situation where you have a company with a subsidiary or something down the chain, then it will not be 739 that applies, it will be the CFC provision.
Does 747 only apply to companies?
Yes. Well, yes, that's right. So it only charges UK companies to corporation tax in relation to the income profits of a foreign subsidiary.
So if SJA had set up SJG as a subsidiary of SJA,
yes, the
tax treatment would have been different?
Yes, that's right. It would have been the CFC legislation we've been looking at, and if that had applied, then it would have been SJA that would have paid corporation tax on the profits of the subsidiary.
Mm-hmm. So the implication of that opening proviso is that 739 is intended to apply to situations involving companies.
It certainly envisages it can. Yes.
Yeah. Okay.
And I'll come back to that when we're looking at what Lord Justice Phillips said, because I think that's one of the answers to the problem of the public company with a lot of the shareholders. But in fact, in nearly all cases, it would be the CFC provisions that would be applicable. The following provisions of this section shall have effect for the purpose of preventing the avoiding by individuals, ordinary resident, in the United Kingdom, of liability to income tax by means of transfers. Now,
I'm sorry to interrupt you again.
Yeah.
So, does 747 then actually deal with the tax position of the company itself?
Yes.
So it's not focusing on directors and shareholders.
No. It's nothing to do with, and it's nothing to do with transfers,
right?
Either.
Yeah.
It's to do with, well, I might show you it tomorrow, a bit of it, but it's not to do with transfers. So it attributes the income to the company, and the company is charged corporation tax on it.
Right. Well, I wonder, having clarified the opening proviso, I wonder if perhaps we should gird our loins for the main body of this tomorrow morning.
Good idea, yes. Thank you.
Okay, well, we'll adjourn then and resume at 10:30.